Welcome to Retired Voices of Reason, where we talk about the uncomfortable topics, but we keep it 100. And I'm be joined by my co-hosts, Law Johnson and Sam Jackson. Today, we're going to be talking about some controversial issues. Everybody's got their opinion. It's like if you're breathing, you most likely you got an opinion about this. So before we start that, I'm gonna let my co-host take it away and get some other issues, some other incidents we want to discuss. Got it, Law?
Well, we were gonna get into the Breona Tyler verdict tonight. Before we jump into that, I just wanted to throw out to you guys, if you saw where in Jacksonville, the FOP had come out with, I guess they were battling with Fletcher High School about one of the students there played on the football team, and I guess he had been running out with the Blue Lives Matter flag before games. And I guess this year when he tried to do the same thing that he'd been doing, Fletcher High School wouldn't allow him to do it. So that turned into a battle with them and the FOP. Allegedly, because they felt like the Blue Lives Matter flag was racist or had some racial overtones or something like that. I don't know if I believe that, but what you think about that?
This Sam Jackson. I'm using the Retired Voices of Reason profile picture because I'm driving at the moment, so I'm going to be hitting off video. But anywho, in this particular incident, when the young man initially started coming out with the Blue Lives Matter flag in honor of a fallen police officer, this was last year before this climate of that we're in now, and because we're in a very heated debate and issue, and it has become politically charged. And so now that's what the principal and the superintendent agreed, that now it's no longer a statement of support for a fallen officer. It is now a political statement, and they wanted to stay away from the political part of it, so they kind of banned that activity. So that was the principal's justification along with the superintendent. So it changed with the changing attitudes. So I understand why.
I can see that.
Yeah, I understand why.
But I agree. But one thing the principal did do, I mean, like you said, the climate changed. The temperature of the country has changed since last year. One thing they did do, and this was the young man was doing it. I think it was two brothers that were doing it in honor of their father, who passed away unexpectedly last year, or maybe a couple years ago. But what the principal did do was allow the football players to put decals on their helmets in support for our fallen police officers. So it's not like they just took everything away. It's just like a few years ago, Colin Kaepernick kneeling was, it was unacceptable. But now
everybody kneeling.
Well, what the superintendent did say, and again, I had to listen to the justification, and she said that she would allow them to individually support their cause because those were individual expressions of speech. But she said when they came out there with the Blue Lives Matter flag, it could be taken as that was the position of the entire school or the administration or the body, everybody. That was their position, and she said that it wasn't everybody's position, so they could not come out there representing it as if that was the position of the school.
Right. That makes sense.
Yeah, totally. Now, I think, Law, you sent me a link today that someone from another high school came out with a banner that said Black Queens Matter. Does that fit into the same realm as that should be off limits as well?
Well,
because they were.
I think in that particular picture I think that was captured by somebody from the FOP, and they were making a contrasting argument that banner was allowed at Westside High School, but the kids weren't allowed to run out with the Blue Lives Matter flag. So if all things being equal, then the other one shouldn't have been allowed as well.
Right. And again, we didn't have no context.
The flag that you were talking about with the Black Queens Matter in the right hand bottom corner, it said Breona Taylor's name on it.
Right.
Yep. But it would still
that one could easily be and I wouldn't even say misconstrued. I think that was more deliberate to say that was a statement about Breonna Taylor.
It was.
I think everybody's kind of making comments and statements about that now.
Yeah. The only thing is, the picture was posted by someone who was trying to make a contrast between the two, but they didn't offer any context. So we don't know if the school officials addressed it, made them remove the banner, if it was just a moment that they captured and now trying to say this was the norm. It's a lot that wasn't said in that photograph,
right.
But they're trying to stir the pot.
Yeah, I call it whataboutism. What about them? What about, instead of taking responsibility for what you're addressing, it's always, you point fingers, what about them? Talk about this right here.
Yeah.
Well, since they had Breonna Taylor on the thing, and we're going to talk about Breonna Taylor, let's dive in.
Well, it's gonna get a little intense. So I hope the viewing audience is ready, because we may have a difference of perspective on this issue, and I'm like probably the one that's igniting this this fire.
And that's good. That's good. We like that.
Yeah. Okay, well, let's get it started.
Well, we can't start till Smokey read his scriptures from he's gonna read something now.
Well, I think I posted something earlier about the prosecutors. Matter of fact, it wasn't the prosecutor, it was the judge. And I don't know if you guys can hear it or not. Let's put it up here about the indictment, what it actually says. Let me get the thing up here. You hear it?
Barely.
It's on the Facebook page. Basically, I'll let everybody else do their homework and go to the page. But the thing is, Officer Hankinson was indicted for shooting into 3 apartments, and in the individuals' apartments that they used the individuals' initials. I think one was CE, one was CN, and I can't remember what the other one was, but it was not PT, Breonna Taylor. So basically what he got indicted and charged with was shooting his rounds errantly into surrounding apartments. it did not address the damage and the injury to Breona Tyler, that what she sustained, which included her death. I also posted quite a few, a couple other articles. That, like I said, I feel like facts, not opinion, not facts, not feelings. So one on there was from the chief, who when he was at the hospital, he was notified from his two head people in command. Initially, what they told the chief that got fired, they told him that Breona Tyler was laying prone in the residence and was shooting a rifle at the entry team when they came in, and that's what led to her being shot and killed. Mr. Hankerson, the officer who got indicted, he was on the perimeter, in which I posted some I think it was like 70 pictures that was in this one article, and it gives you of the scene. I mean, you got a duplex apartment, two apartments like on one, then you got above apartments, and you got stairwells. They were on the right-hand stairwell to get everybody visual, and they made entry with the ram. You could see where they laid the ram down on the side, which is the big metal object that breached the door. Mm-hmm. You saw, I think it was a comb that designated the crime scene evidence. There's a comb inside the door, just one comb, and then you had numerous combs leading out toward the parking lot, including in the parking lot. And then you had, it had a bunch of shell casings. Then you had the sliding glass door, which was to the right of the stairs, which was to Miss Taylor's apartment, and the glass was completely shattered and looked like total chaos. One interesting thing is that the briefing was done with SWAT, because SWAT hit their apartments. I think they were on, I think it was Lexington. They call it Lexington Avenue or something like that. Anyway, Breona Taylor's apartment was known in the Springfield area, Springfield Road or area, whatever that is. It's totally separate parts of town. The SWAT team during the briefing, the Springfield area was not brought up. So they knew they were hitting multiple residents, but they did not know that somebody was going to hit the Taylor residence. So the SWAT commander or lieutenant, I can't remember his name right off the bat, but he was, like I said, I posted his internal affairs testimony, which you actually hear his statement in 30 minutes statement. He stated that while they were breaching their apartment, they got a call over the radio, shots fired, also down. And he was calling it, he thought it was at his location. He was making sure his guy was okay. And they was like, yeah, we're everybody straight here. So then they went to another channel, and they was like, no, we're at the Springfield location. We need officers here. So he loaded up some guys, took his Bearcat over there. And he said when he got to the scene, he saw total chaos. I think it was a total of 6 officers at that location that made that entry. He said when he got there, he noticed that the glass door was shattered. The screen, the sliding glass door was like Swiss cheese. And he thought the shots came out of the apartment toward the officers. So he goes out. They sent a robot in to make sure nobody else was in there. They said that, they let him know that, hey, they already had the guy in custody, the male in custody, but there may be possibly a female in there, and other people might be. So they sent a robot in, like a drone. They saw Miss Taylor laying on the ground motionless. So then they went in and made entry to make sure nobody else was inside. And when they looked at the glass door and made a motion toward it, they noticed that Hankerson kind of puffed his chest out and said, yeah, that's me. I did that right there, And so I know with JSO, we had and I was involved in a couple of officer-involved shootings. And when the incident happened, right immediately after it occurred, we all separated. Everybody involved got into different places. That way we didn't come up. Nobody can hear what everybody else said to get the story, everybody on the same page type of thing. All they told us to do was, hey, stay calm, don't say nothing, wait for the FOP rep to get here. detectives, the on-call state attorney, and whatnot. And from what I understand, Louisville had the same type of policy in place, what they call like I guess like a battle buddy type of thing, or escort. And in this incident, all the people involved was just walking around like nothing happened. They were unaccompanied. Hankerson, the one that was indicted, he actually walked into the crime scene a couple of times. First thing he asked was, did y'all find a gun? Then the guy with the SWAT guy was like, no, there's a round that looks like one of our rounds. He's like, no, you shouldn't be in here. And then then Hankerson asked the SWAT guy, did you guys find a rifle? Did you find a long gun? A long gun is what they call they call it a rifle. He didn't ask for him, or he may told him no, but he told him, hey, you need to get out of here. This is a crime scene. You need to abide by the policy. What Hankerson did was he left, got into his vehicle, drove to the hospital where I think Mattingly was the sergeant who got shot. And when he got to the hospital, the chief was there. The chief that got fired, he was there. So Hankerson tells the chief about what transpired. He said chief said, hey, he was really nervous, like very hyped up. He's like, hey, worried about his job. He said, am I gonna be okay? Am I gonna be all right? Chief was like, yeah, this shit, we're gonna see what, we're gonna see how things happen. We're gonna see what happened, what's up. And he was like, and that's when the chief found out that Miss Taylor was not the shooter and she didn't have a rifle. It was the male because Hankerson said, hey, we got the male in custody who shot the sergeant. And she was like, what do you mean the male? He said he wrote that down because it was a discrepancy from what his people, his staff people told him. So after that, so that was another violation. The chief said another thing. He's like, this guy wasn't following policy and protocol with a police-involved shooting because he had drove to the hospital by himself. He wasn't with somebody and he wasn't at the scene, and it was just, he was freestyling, doing what he wanted to do. We're going to spin to another side of the story. The night of the incident, they had like 11 or 12 apartments, asking witnesses, asking everybody if they heard anything, if they heard the people announce. Well, let me back up first. First of all, before they executed that search warrant at Miss Taylor's apartment, no, it was a no-knock search warrant, but they were informed that the primary subject was in custody. And so that took the no-knock off the table. So they had to make a knock and announce. So they asked everybody, the neighbors, everybody, did you hear the police? Did the police announce themselves? Everybody said no that night. Everybody. The guy that eventually came forward, I think this was like March the 12th that the incident happened, March the 12th or the 13th. On this date, the guy, they got him on recording that stated, hey, no, the police did not announce themselves. I know it's the police because they had vests on. He's a truck driver. He went to pick up his daughter from a babysitter that lives right above Miss Taylor's apartment. He saw all of the cars lined up. He saw the Focus. Matter of fact, he got into a verbal confrontation with Officer Hankerson, the one who got indicted. So he said, no, the police never announced. They never said they were police, anything like that. So I think Internal Affairs or one of the investigators tried to call him on, I believe, April the 1st. They left a message for him. He didn't no contact. He called them back a couple of days later, left a voice message. And after the third time he got in touch with them, they had him go down there. They interviewed him twice. So that's the total of 3 times. The first time he said no, he didn't hear anything. Second time, obviously, they needed a third interview. And the third time, which was on, I think it was in May. It was like 2 months later. He was like, oh yeah, I remember. Yeah, they did. The police did announce that they were the police before they went in. And then listening to this guy's voice, and I looked at a couple of pictures of him, and you know how you can look at some people and you can tell like they may be kind of slow, or they're not as sharp as the average person. Yeah. This guy, he kind of fits that profile. Like he would be very easily manipulated. And coincidentally, his girlfriend, his fiance, she had some charges of child abuse, I think back in 2019. And I don't know what happened with that, but maybe, certain tactics can be used to persuade people to do certain things and say stuff that they normally wouldn't say. So that's another something that didn't really come out. But it was a soup sandwich it's a lot of information that's trickling out that wasn't put forward at first. Like I said, it was a cover up. And the thing is, if you remember, the Breona Tyler incident happened before the, what's the name? This guy killed Floyd, before George Floyd. So after the George Floyd incident is when they raised the ruckus, and the sister reached out to the activists and said, sister, because we don't know, they're giving us the runaround, which they had been, so that's, it's I'm kind of reserved, but when you see certain things, it's like and we always talk about transparency and leadership. You got the head of the department being lied to by his people, and you got departmental policy that's not being followed, that there hasn't been any repercussion of, no violations of department policy, of not, especially a shooting. That's an awesome about shooting. If you want to be on your P's and Q's and have your I's dotted and your T's crossed, that's the very time that should happen. And I can go deeper, but I'm gonna let you guys chime on in.
Well, here's where I'll just throw out, because you gave a whole lot of information, and some of the things that we were talking about off air that I'll kind of bridge the gap on is my whole issue with all of it. Even though you got step by step, there were issues, it was shoddy police work and other stuff. But my whole issue with all of it is you had law enforcement professionals shooting, even with those pictures that you posted, shooting that many rounds at a target that they weren't aware of. Particularly the officer that was outside, because I think a statement that he made was that he was shooting at the muzzle flash that he saw coming from inside the apartment, which is why they believe he's the one that shot the officer in the leg. So, but my overall issue with it all is you got one officer that was indicted for, like what we were talking about off air, shooting and hitting something else other than what you was intending to shoot at. But nobody was indicted for that same crime that ended up in the death of an innocent person. So that is where I'm left. That's where I'm stuck with. How does an officer that was legally right to be there based on the search warrant or arrest warrant, and okay, you enter the house, you take fire, you return fire, but you start hitting other places, and clearly you can tell by the scene that those weren't shots that were taken at a target. Those were like, cover your eyes and shooting or something. There's bullet holes everywhere. So, like we were talking off air, that's negligent, which is why the officer that they claimed that did that shooting got indicted. So my question falls back to, if that officer can get indicted for essentially property damage with bullets, why can't the officer that was recorded as the one firing the fatal shot for Breona Tyler couldn't be indicted for negligent homicide? Come on, Sam.
Okay. Richard laid out a very eloquent visual of the scene and what transpired during and after. I'm taking it from a different angle. You know, we can have our opinions, but if we're seeking justice, let's be fair, you know, about this thing. And justice has to be fair and it has to be consistent. And when you're talking about legal justice, you have to follow the law. So I'm going back from the beginning. And first thing that says, okay, what did they make their ruling on? Because they're not saying. So it's up to us to surmise, what did they make their ruling on? So as a law enforcement officer, I always have to default, well, what does the law say first? Because we have to apply the law, then we have to apply policy. So first of all, and as me and Law was discussing, and my understanding of the law, that in order for you to have a crime, you have to have malice intent. Without that intent, you don't have a crime. You could have negligence, things that happen accidentally, but you have to have intent and it has to be malice. So first of all, that's what the law, that's the standard of law. So we're going to talk about applying the legal definitions as we proceed forward. So first, we got to ask yourself in this decision, did those officers set out with malicious intent? No, they didn't. And if we speculate, that's only our opinion. You cannot prove that they set out with malice intent. Secondly, were they there lawfully? Yes, they were. No matter how you spin it, they had a signed affidavit from a judge to execute a search warrant. It was not an arrest warrant, it was a search warrant. So they didn't have to be looking for anyone. The ex-boyfriend didn't have to be there. The Taylors didn't have to be there. No one really had to be there because they wasn't looking for a body of an individual, because it wasn't an arrest warrant, it was a search warrant. So they was looking for evidence. If people are there, then you have to deal with the people on scene. So they were there legally. No matter how we spin it, no matter what happened afterwards, they were there legally, by, you know, authorized legally. So there are certain things, me and Law was debating this. Our officers, law enforcement officers, are exempt from certain crimes because they have to have some latitude. So a law enforcement officer is given certain rights and authority above the average citizen. That's called acting up under the color of authority, meaning that in order for you to carry out your duties, they give you certain exceptions and certain latitude. Secondly is the good faith rule. So whatever information that these officers brought to a judge to get that judge to issue and sign off on that warrant, the judge took it as good faith. You have to have a certain amount of trust in law enforcement officers. Now, if you want to debate if that trust is being eroded, I'll agree with you all day, because that's why we're here, because the trust in law enforcement is being eroded and it's being challenged on everything now. They're no longer being given the benefit of the doubt. But back, they were there serving a legal search warrant. Now, once they got there, you know, it was a no-knock search warrant. Even though they, like Richard said, they found out later that, hey, the guy isn't there. Well, he don't have to be there. I'm not there serving an arrest warrant. But I still have in my hand a no-knock warrant. So from a discretionary standpoint, if I want to change whether I knock or don't knock, that's my discretion. But if I still do not knock, I'm still legal in the service of this warrant, because it's a no-knock warrant. So the debate whether he announced or he didn't, I don't think that's really relevant, because he had a authorized no-knock warrant in his hand. Secondly, were they justified in using deadly force? As law enforcement officers, they were fired upon. But the guy that fired upon them, he had legal justification to fire, because if they did not tell who they was, if they did not acknowledge themselves as law enforcement, that homeowner or that citizen could very well believe that it was an intruder and he can protect his home. So in both instances, both sides were justified in firing their firearms. Okay, so the civilian fired upon the officers thinking it was an intruder. The officers there legally returned fire because now they're saying we're being fired upon while we're executing our lawful duty. I don't have a problem with that. Here comes the problem I have, is that nothing that they did at this point from an officer standpoint, nor from the boyfriend standpoint, is criminally wrong. Now we start to question their training, their tactics, and all these and policies, departmental policy. We're starting to question that. None of that is criminal though. And you penalize someone who did not do anything criminally, you penalize them civilly. And they are being held to account from a civil realm because you can show that there was negligence. You can show that, they did not follow departmental policy. That's not in question. The question is, can you charge them with a criminal homicide? I don't think so. Yes, someone died, which is a homicide, but it was not criminal because they did not set out to kill anyone. They set out to execute a legal search warrant. So that's my position.
Answer this for me.
If
you saying they can't be charged for the homicide, how is it that the officer was indicted for the property damage? Or because he endangered others by his bullets going into their apartment.
True. And now we're talking training that the other officers, they knew they were being fired upon because they was coming through a door. They returned fire in the direction that the shots were coming from. This officer that was charged with wanton and willful endangerment, from what I read, he was at the patio sliding glass door. And from what I read, it had a curtain in it. So when he heard shots, he just started firing. He had no target acquisition. He had no backstop.
That's the one that they say shot the officer.
Discipline. Huh?
That's the one that they say shot the officer.
No. This was the one who shot into 3 different apartments. He's just shooting aimlessly. He was at a side entry at the sliding glass door. The other officers was coming through the front. So when he heard the gunfire, he just started shooting. He couldn't see anything.
He was shooting at the muzzle flash. That's the one that was shooting from outside, shooting at the muzzle flash.
Well, he must have saw it through a curtain, and this is only what I read, just like most of us. There was a curtain over the sliding glass door, so he couldn't see in. So yes, possible he saw a muzzle flash through the curtains or whatever was covering up that sliding glass door. So he was reckless. But
so go ahead, Smoke.
First of all, manslaughter, the crime of killing a human being without malice or forethought or otherwise in circumstances not amounting to murder. And in legal sense, it says manslaughter is a common law term for homicide considered by law as less culpable than murder. The distinction between murder and manslaughter is sometimes said to have first been made by the ancient Athenian lawmaker. So manslaughter is a charge. It is a criminal charge. The first thing an attorney does on a search warrant, and we've talked about this before, even searching a car, illegal searches, fruits of a poisonous tree. In obtaining the no-knock search warrant, they claim, it was sworn to that the Postmaster General confirmed that several packages that were suspect of drug use, a drug-related industry, were being sent to that residence, to that location. The Postmaster General said that did not happen. That's a lie. The second thing is that they, with the shot, the officer who was shot, the autopsy and the evidence shows that it was unable to determine if he was shot with friendly fire or he was hit by Mr. Walker's one round. So that was not able to, they weren't able to be determined that. They stayed because some of the way the powder residue and the angle, it's quite possible that he got shot with friendly fire because it was a 9mm round that hit him. So
the local sheriff's office, and again, we're all reading various news sources, but the sheriff's office was unable to determine a lot of which rounds was fired from which weapons because they didn't have the ballistic testing. But once it got sent out to the, I think it was the FBI or something, they were able to accurately confirm which rounds came from which weapon. We're in that time and technology where this can happen. They wasn't able to do it promptly. And again, that might have contributed to the length in the investigation, because it was turned over to another agency. But initially they wasn't able to determine which round came from which officer, but ultimately they were.
But the FBI haven't released the information if they determined that the round came from Mr. Walker's gun or another gun because of the fragmentation of the round. But they're still investigating, so they haven't released that information yet. The sheriff's office stated they couldn't determine it, and that came from the sheriff's officer and the medical examiner. So it's still it's not concrete. Yeah, that's the round for Mr. Walker's gun that hit him, or yeah, he was hit with friendly fire. Only the feds know that. At this point, it's tomato.
That, to me, that's really a moot point, because if you come in a house and you hear a gunshot, the assumption is that you're being fired upon. So I get returning fire. The issue for me comes in as to where when you're returning fire and you go sit before the firearms review board and they ask you what or who were you shooting at, you got to be able to explain that. And you also got to be able to explain what or who was behind what you were shooting at. And that's where we Sam and I verge off from the same path, because veer off from the same path, because when you look at those pictures and all of those bullet holes all over that apartment and other apartments, the person that they were shooting at was not in all of those places, which I believe, and Sam, you even said it, which led to the officer that was outside shooting in, why he got hit with the charges he got hit with, because he was essentially doing outside what they were doing inside. And so that's where the question for me comes in, is how is it that he get charged with doing what they were doing? He was outside, they were inside, they were doing the same thing, but they can't trace none of his bullets into killing her. But one of the officers inside, they traced one of their bullets to killing her.
Yeah, but Law, there's no question someone died. The question is, was it criminal intent? And until we answer that question, we're gonna go back and forth.
But you don't have to have criminal intent for negligence.
For manslaughter.
That's why you deal with that in the civil. That's why you deal with that in the civil realm. If there's no criminal intent and it's just negligent, you deal with that in the civil realm.
Not negligent homicide.
Not for manslaughter.
As a civilian, you're right, but a law enforcement officer are exempt from that, because they were there.
Sam, they charged
with legal authority.
They charged the guy. They charged the guy. Yeah, they charged the officer that was shooting from outside. They charged him with basically what would be ag assault in Florida. That's basically what they charged him with.
But we're talking, the public is crying for a charge of criminal murder, and they don't have enough to charge nor convict on criminal murder. So they went with the lesser charge, which again had nothing to do with Breonna's death.
They charged the guy that was shooting from outside. And I'm not
Yes.
so much concerned with what the public want. I'm talking about what actually happened. The officer that they have identified that fired the fatal shot to Breonna Taylor was not charged with anything.
Correct.
So the question for me is, how do you charge a guy that did the exact same thing, but he hit property and the other one killed a person?
You know how? One thing I noticed, and it's not always what's being said, but you got to listen to what's not being said also. And in presenting the case to the grand jury, you either come back with an indictment, you come back with a no bill, or you come back with a true bill.
And they didn't come back with a no bill.
No, exactly. They didn't come back with a no bill or a true bill. They came back with an indictment of one individual. So what's that information? So with that evidence right there, with only thing we got is what we go on. And with that being said, it appears that, and like I said, it appears that the evidence relating to Breonna Taylor's death was not addressed in that grand jury.
I agree. I
believe that is what the outrage is, because it's the lack of transparency. If you didn't present the evidence, say, hey, we didn't even address that. We're going to do it at a later date. We're going to do it at a later time. We're going to let the feds handle it. But
the grand jury was looking for a crime. They were looking for a crime that occurred, and they didn't address it openly because they didn't find the elements of the crime, and you got to have intent. And I know this is tragic,
but there's only one way that they would have sent it back if they didn't find a crime, and they would have said no bill. They didn't do that. So it's either an indictment or it's no bill. And if they didn't go no bill, then you got to go, okay, well, they obviously didn't look at this information because they didn't rule on it at all.
It's like a court case. If they either going to find them guilty or not guilty or acquitted. But they're going to say one of those three things.
And so by that not coming back from the grand jury, and the only thing that came back was an indictment for basically aggravated assault, then you have to go, okay, well, did they even look at this information?
Well, answer me this. Isn't the whole purpose of a grand jury is to determine if you have enough to support the charge of a criminal violation? Isn't that the whole purpose of an indictment? And if they did not have enough to support a criminal charge, it doesn't go forth on a criminally.
But what I'm saying, Sam, is if they didn't have enough, they would have said no bill on this charge. They didn't do that.
You've heard that they said an attorney can indict a ham sandwich if they want to. It depends on what evidence is presented to the grand jury. If you don't present certain evidence, they're not going to address that. You're not going to. That's the only thing they can go on is what you give them.
So since they didn't return an indictment or a no bill on the person that they claim credit for killing Breonna Taylor, they didn't come back with an indictment or a no bill, which means they obviously didn't look at that information.
Okay.
Or that information wasn't presented to them, because that's the only logical explanation for me for you indicting somebody that was, like I said, aggravated assault. You indicted him, but you didn't indict the one that actually you laid the credit to for committing murder. But like Smokey said, the grand jury on that charge didn't come back with what a grand jury would come back with, either an indictment or a no bill. They didn't do it. So was that information presented? Couldn't have been.
I'm sure it was. This is a serious allegation. You have to look at everything. I mean, if we sitting here as retired officers that don't have half the knowledge of an attorney or a judge, if we can plainly see it or come to these conclusions, they have to see it. Now, we have to be reasonable. These are professionals. Now, we can say that something in the mix ain't right, you know, and I'm all for justice, but justice is about being fair and consistent. And we have to apply the rule of law. And if you don't apply the rule of law, then that ain't justice. That's just a mob.
Well, we are applying the rule of law because if they had presented the case or the part of the case that involved Breonna Taylor to the grand jury would have came back and said something. They didn't say anything on that.
We don't know what all they said. All we've gotten from social media and news outlets is that the grand jury did not move forward with a murder charge. That's all we got, and that's when shit hit the fan.
No, if you watch the press conference that the Attorney General gave, he did not mention anything about the Breonna Taylor suspect, if you want to call it. He didn't mention that at all. At all.
And neither did the judge. The judge didn't either when she read the indictment.
They didn't mention that at all. The only thing they talked about was the officer that whose bullets were traced into hitting other parts of the apartment, which is another indicator that the grand jury never ruled on the aspect of the case related to Breonna Taylor. Because there's nothing in court documents that comes back with anything that the grand jury would have said. They didn't address it at all. So what you left with, I mean, if they don't say nothing, because they come back with some kind of response.
So let me get some clarification for the viewing audience. I keep referring to officers have certain exemptions and immunities. Can you explain to our viewing audience what does acting up under the color of authority mean and the officer's good faith rule? Can you explain to the viewing audience how that applies?
I would say in this case, everything was good faith, at least on paper, and under the color of authority up until shots start being fired blindly.
Here's an example.
Yeah, go ahead.
I found this was September 3rd this year. Police officer charged with manslaughter in fatal shooting of black man at California Walmart. Charged with voluntary manslaughter after, let me see. San Leandro police officer Jason Fletcher shot and killed Stephen Taylor less than 40 seconds after he entered a Walmart where Taylor was allegedly trying to leave without paying. Said that Fletcher's use of deadly force was unreasonable in part because of his failure to attempt to other de-escalation options. So that's a manslaughter charge. You also got an officer, wasn't the one who killed Both and John, was she charged with manslaughter?
I don't remember that what her charge was, but I'm in this case.
But she was
I wouldn't even say. I would lean more towards negligent homicide because the actions of the officer that fired the fatal shot were negligent, particularly if you can't tell me what you were shooting at, who you were shooting at, and what was beyond what you were shooting at. Y'all seen the pictures, man. They got bullet holes everywhere. They were shooting all over that apartment.
It was like a drive-by on foot.
Exactly.
Yeah, but that don't make it criminal. That makes it negligence.
But that's what throws you into the criminal realm when your actions under the color of authority are negligent.
If a doctor is if he's doing surgery on somebody, he's under the influence.
There goes
you don't mean to kill this person, but they die.
You're as a doctor, you're not supposed to be inebriated. You're not supposed to be inebriated doing surgery.
But you're not supposed to be shooting indiscriminately at targets you can't see. What's the difference? You're doing something you're not supposed to be doing.
Okay.
That's
You know,
that's
if a
that's what
driver-
throws
if a
it
bus
into
driver-
the negligent homicide realm. Is he was
Right.
doing it and they were shooting and couldn't see.
Right. If a bus driver hit somebody crossing the street and they ran a stop sign,
Yeah.
they didn't mean to kill that person, but their
Yeah,
actions led to that. They're
we
gonna
giving
charge
them,
manslaughter.
we giving a lot of examples, and so we just going round and round with this until we get someone who's gonna give us a legal ruling. We're gonna be stuck right here because you giving me a lot of examples, but we need
But
to have.
I'm giving you the law. I gave you the law giving you the law.
Yeah. So we gonna have to have a legal ruling, and we're not having that right now because if you change any of the circumstances, the whole outcome could be different. So we can give all these examples, but the circumstances and the elements of the crime, they all have to line up in order for the decision to be the same. So if you throw something
Here's what we know
different into the
that's a
mix,
fact. This is what we know that is a fact. The grand jury did not indict, nor did they come back with a ruling of no bill on as it relates to the Breonna Taylor aspect of this case. So the fact that we don't have either of those rulings says to me that they were not presented with that information to rule on.
but you have nothing to support what it says to you.
Well, I do because I know what grand juries do whenever they rule on something. If they're indicting, they indict. If they don't indict, it's not like they're silent. They tell you that they're not indicting.
Now we
and it's called a no bill. They come back with a no bill when they're not indicting. We don't have that in this case.
All right.
So I guess the question would be, if you don't have an indictment or a no bill, what would cause that? If the information was presented to the grand jury, what would cause that? And my experience with grand jury is if they don't come back with one or the other, that information weren't presented. That's like having a criminal trial and you don't get a guilty plea or an acquittal.
Yeah, and
we got somebody had a very good question. It's along these lines. That Carmen, I think Menifee, said, "What if the officer who was charged with shooting in the other apartment had hit a person? Would that have changed the charge? One of those bullets, one of those walls would have hit a person in the other apartment. Would that have been the charge?
Yeah, because he got charged with wanton reckless endangerment or something like that, which he got charged with basically aggravated assault, basically is what it was.
So what's the difference between hitting a person who's in another apartment that didn't shoot at them and hitting a person that's in the apartment that didn't shoot at them?
Because you got willful and wanton and reckless endangerment to support that charge of someone being killed. You have that to support that. You don't have the willful and wanton part on the other two officers. You have them acting in a legal capacity, void of training. So there is your difference. That other officer, he was obviously, or they had proved, or he had enough to show that he was reckless in his actions.
Or like what we already said, the other information just wasn't presented because nobody that has talked about this in a press conference, the attorney general or the judge, neither one of them talked about the Breonna Taylor aspect of it.
Or Benjamin Crump, he's a lawyer. He's not even talking rules of law. He comes in here and he's talk like he's a civilian standing on the perimeter, talking. He don't even talk in rules of law. And this is just my opinion of him, he talks to incite because there's a big payday at the end for him. Now, I'm not saying he's not seeking justice, but as an attorney, You still
Oh, he
need
already
to
got
give
his
us some
payday.
law, some legal basis, and very seldom does he do that. And he should be bringing out all these inconsistencies and the application of the law. And I don't hear it. Maybe I don't listen to him enough. But what I hear is he's sounding like a straight up protester versus a legal attorney that have a vast knowledge of the law.
He pretty much, he's a figurehead. He doesn't, he's not even looking at those cases and researching. From what I've seen and from the other cases that I kind of got my own personal opinion about him and keep to myself. But I just say, I ain't gonna use him.
But if he wanted justice, he would be fair and he would be just as transparent, and he would be telling his supporters and his audience, listen, here's the law, and this is what we want them to rule on. Let's apply the rule of law and let the chips fall where they may. If he's so confident, then why?
I forget the female name. He has a co-counsel there, and she has made the same comments that we're making about the Breonna Taylor aspect of it was not addressed in the grand jury summation because it's like they didn't say anything about it. So you don't present a case before the grand jury and they review it and then they don't say anything about it at the end. That's not how they function. So that's why they want the transcripts of what happened in the grand jury testimony, because they didn't get the end result of what a grand jury would give them at the end result of a grand jury case.
All right.
It's you got to put yourself in the position of not only the family but the friends, and then you see people, they've been seeing people get killed and get mistreated and things over and over, and it's the lack of transparency. First of all, you had to practically pull teeth to get this brought to light, to get some type of justice, because it appeared to have been tried to be swept under the rug until the rug was pulled up, and now you're trying to get a little bit of dirt, but you're not showing me the whole thing. I want to see it is what it is. And that's how I am. I'm like, if they didn't do anything wrong, show me. If they did something wrong, show me. I just want to see. That's it. It is what it is.
Well, if you're going to make that statement, then we're talking fairness again. If you're not getting all the information, then you would be premature in making a judgment call. And you're admitting that they're withholding information and you're not getting enough. So demand the information and be patient on the information to come out, but you're still making a judgment with the lack of information. And all I'm saying is, with the lack of information, apply the rule of law on what you know. And you can't speculate from a legal standpoint on what you don't know. So it's not what you know, it's what you can prove. Going back to one of my favorite movies.
But
all
I did was present what was not put out publicly and what was kind of getting glossed over. Personally, I haven't made a decision one way or another. Should they be there? Because, like I said, I go with the evidence. I go with what leads, because in all those years of law enforcement and investigation, I know for a fact everything ain't like it used. I've had people that I've locked up based on witness statement, positive IDs, and it looked like, you had people, the independent witnesses, and they end up not being the person that did the crime. And I went to the judge and got those charges dismissed a couple of times, because all I could do was go on based on the evidence I had at the time. So I know for a fact, you don't go with personal feelings. You take your feelings out or what it looked like, you go with what it is.
And that's what I'm advocating. And that's what Benjamin Crump should be doing. Just like you said, if there is more evidence out there, him and his team should be out there uncovering that evidence, presenting it to the grand jury. That's where I'm at. All I'm saying is, I'm not making a judgment. I'm just applying the rule of law on what we do know. And I know
but they doing that. That's why they're asking for the transcripts from the grand jury, because of what me and Smoke just said. They recognize that the grand jury failed to acknowledge or address anything about how Breonna Taylor died. Like, that was not in any of the indictment paperwork. They didn't address it at all.
But did
It's
the
not
grand
like
jury
in the
have
Michael
more
Brown
information?
case where they didn't indict, huh?
I said, but did the grand jury have more information, even though we're not being presented with it? Did the grand jury have more information to base their decision on?
But that's what you're not understanding. Whether the grand jury had all the information or none of the information, they didn't make a ruling on anything relating to how Breonna Taylor died. So the point is, if the case for the officer that they identified as the person responsible for killing Breonna Taylor, if the case was presented before the grand jury, they would have came back with either an indictment or a no bill.
So why didn't they? If that's a rule of law, if that's a standard, or if that's proper protocol, why didn't they? I mean, there's a reason.
So,
there's a legal basis
right.
for
So
everything.
that's what we're saying. The only reason why that we know of is the case couldn't have been presented before.
Okay.
The grand jury only goes on the information that's presented to them by the prosecutor.
The
defense attorney can't call a grand. The only person that can bring whatever information the prosecutor brings up, that's what they get. Now they'll ask witnesses. If you called in there, they can ask you questions, and that's what you can answer. But if the prosecutor don't bring it up, they don't lead you a certain direction, and they can do that. They can ask. What they do is because I've testified in a few grand juries, they ask you a question, you give an answer. You get an answer that you pretty much or what they want to get. If they want to indict somebody, they're going to get the indictment. So they're going to tell you, okay, this is what we're going to ask you. This is what you need to address. And if the jury asks you, be prepared for the jury to ask along these lines. Now, the jury can ask off the wall questions like, what color was his shoes? If I don't know, I'm saying, I don't know. I don't realize it wasn't in my notes or, whatever. But they can ask whatever they want to ask. But the only thing you can they get is what is presented to them.
And what I'm saying is, whatever is presented to them, they don't come back with nothing. Like if they're not going to indict you, they tell you that. If they indict you, you indict it. It's not like complete silence.
Yeah, they don't just say no charges will be found. It has to be something, a legal documentation of what that case, how it ended, how they saw their decision, that court decision.
And
that's no bill.
That's why they're up in an uproar now with trying to get the transcripts, because the grand jury did not address the Breonna Taylor aspect of this at all. And so it says, okay, y'all obviously didn't present that part of the case to the grand jury, because the only thing they made a ruling on was the officer outside shooting back into the apartment.
So is the case closed, or is it still open, pending further evidence?
Well, they can still,
I guess it depends on what's your opinion of what closed is.
Well, apparently they done made a ruling on who they gonna charge and who they're not gonna charge. So to me, they feel as though they had enough evidence to make a decision, and they moved on from it.
But see, that's the thing. They didn't make a decision on who they're not going to charge, because the grand jury never ruled on that.
So is it still open?
It might be because they didn't want to conflict with the federal investigation, because they do have an active federal investigation that's going on right now. So that might be one of the reasons they didn't present anything from the Breonna Taylor residence to that grand jury, because it would have conflicted with the federal investigation, because all of that stuff would have been privy to a public request, just like they're doing right now for open records.
So is the federal investigation, is the federal investigation, is that a criminal investigation or a civil? But the civil investigation done been dealt with because they got the 12 million.
Yeah, the civil case is over with. This is all criminal now.
Yeah. And that's just like with Mr. Walker. His charges were
dropped.
They dropped the charges on, but they can still pick him up after. He's still not off the hook. He can still get charged. So he's like in a holding pattern.
He can get charged by whom and for what?
He can be recharged with assault on officers, attempted murder by the state. The state.
So,
the state of
But
Kentucky.
the state dropped his charges initially, but they didn't drop them like no pros. They I think they said they dropped them with privilege. I think that's what it's called.
okay.
But they didn't. It wasn't no pro.
Well, what we need is an attorney on this panel, because I'll admit, so I want everybody to know, I'm not a JD, I'm not a jurisprudence, I'm not a judge. My knowledge is nowhere near to that extent. I'm giving you my perspective based on my knowledge as a law enforcement officer. So we do need someone with a more in-depth knowledge of the law to give us a little bit more insight. Now, we're making some great points, but we don't have anybody to rule on these differences of opinion.
Well, I think me and Smokey gave you the law. You just don't like our opinion. We gave you the law, man.
And that's the same way I'm feeling. I'm feeling the same way.
We gave, but we gave you the law because, and I think as proof of what we're saying, the same actions that the guy whose bullet actually killed Breona Tyler took place from a guy that actually got indicted. It was the same actions. They had the same negligent actions. One just got indicted, and the other one, nothing was decided at all because there's no information at all about it. So it could be what Smoke said, where they didn't present it to the grand jury because of the FBI end of it. But I'm thinking if that was the case, they wouldn't have presented none of it to the grand jury.
I need facts. I need facts. I need you to stand on some legal basis. I don't need what Smoke think. I don't need all of the feelings. Right. I need some legal facts.
Here go to legal basis. You as a law enforcement officer cannot just start firing weapons willy-nilly at folk and think that you can get away with that just because you had a legal reason to start shooting the first bullet.
And the officer did not fire willy-nilly. They fired because they were fired upon.
So
now they were reckless.
What reckless? They were reckless. Once you do that, you commit a crime.
So
that's negligence. But I'm done. I can't go no more. I got to get off this merry-go-round.
Basically, this is like self-defense. Mr. Walker shot one time because he thought it was intruders breaking into his house. He shot one time. They shot 32 times.
Doesn't matter. They were still justified in returning fire. They could have sent a grenade launcher in there. They were still justified in returning fire.
But they weren't justified in returning fire once the person that they were shooting at was no longer standing in front of them.
Right. Just like this example, if a person slapped an officer and the officer slapped them not once, but 32 times, would that be excessive force?
You fire until the threat is neutralized.
Would that be excessive force? If there's one time, it takes 32 slaps to neutralize that one slap?
Yeah, if he's still trying to slap back, he might get a 33rd. Until the threat is neutralized, you continue to.
But that's the problem, Sam.
You can hear one.
You saying until the threat is neutralized, they didn't even see the threat anymore because
they didn't even hear it.
All right,
they didn't even hear it. It's one shot.
And here's the other thing: how is it that you're returning fire at somebody that shot at you, and you shoot everything but him?
Firearms training, like they need to be on the range.
And he shot first. They need to
be on the range. You know, we're not. What's in question is not their training, their firearms proficiency, because we know they didn't have a whole lot. What's not in question is their backstop and target acquisition. None of that is in question. What's in question? Did they have criminal intent? That's all I'm asking.
But you don't have to have criminal intent if your actions were negligent.
Right.
Okay. All righty
It's
then.
legal.
Now, and that's the law that you don't want to accept. That's
That
the
is the
law.
law.
Okay. All right. And I'm not above saying I could be wrong, but you two guys have not convinced me on a legal basis that I am wrong.
No, I'm just
But
saying.
we telling you what the law is, man.
And I want to come over to your sides. I really do. But I want y'all to be open-minded to come into my side also. You know?
I feel you.
Well, I'm open-minded and I'm willing to give the law enforcement, even though there was some shady stuff all the way up until they came in, I'm willing to give them the benefit of the doubt all the way up until once they start shooting and you are no longer shooting at the person. Like, you can't tell me all 32 of them shots was fired at the dude that shot at them. They can't even testify to that. Matter of fact, the dude on the outside said that he was shooting at the muzzle flash.
But bad shooting ain't criminal. Bad shooting from an officer is not criminal.
Bad shooting is criminal when you endanger lives of other people or kill somebody.
Okay.
Now, if they would have killed the dude that was shooting at them, totally different story. Totally different story. But because he didn't even get a scratch, pinch, nothing. I don't even think a helmet was out of place. And you ended up killing somebody innocent and then doing property damage to other places. I guarantee you, if, like I said on the other night when I was on that show, if Breona Tyler had been a 2-month-old baby, the officer's bullet that was responsible for that would have been charged. Indicted. You doubt that?
I would have to know what legal basis we would have for that charge.
It's the same legal basis they charged the dude that was shooting out from outside.
No, you're introducing a sentimental scenario where you're pulling on people's heartstring because you made it a baby versus a grown man in possession of a firearm defending himself, going for broke. You changed the whole scenario by pulling on somebody's heartstrings.
No, what I'm saying is if they were shooting at dude but ended up killing a 2-month-old baby, they would have been charged. Whoever was responsible for that would have been charged. That wouldn't have been just no oops, we sorry.
I need to know the circumstances.
The same exact circumstances. Just change Breona Tyler from a 26-year-old EMT to a 2-month-old baby.
The optics would be the same, and what I'm saying that to be the same would be that is both tragic. An innocent person died, whether they was a 6-month-old infant or a 26-year-old EMT. It was a tragic incident, and I'm not downplaying it. I'm acknowledging it was tragic, but we still have to apply the rules of law.
But it should be based on the fact that somebody innocent died. It doesn't matter their race, their age, or anything.
And there are rules for that as well. So let's find out what the actual rules are, because somewhere there's a disagreement. And I'm saying officers are immune from some actions if they're acting in an official capacity and they're doing everything legally. What they did not do properly was follow some departmental policies and some training, and that will be addressed in the civil realm.
Well, they already dealt with the civil case.
Negligence.
They already dealt with the civil case. The issue
they dealt with the civil case by awarding them the $12 million, and they dealt with the criminal case by saying they did not find enough evidence to support a criminal charge.
But they didn't say that.
Okay.
They didn't say that. The grand jury did not come back with that.
But it's not finished either, because the feds can also charge them criminally. Remember the Rodney King beating?
Right.
Those guys were charged criminally statewide, and then they were charged and they were found guilty in federal court.
Right. They were not guilty in state court, but guilty in federal court.
I'm going to read some definitions for you, brother.
before you go there, when
Uh-huh.
they take it to the federal court level, they are looking for the charges of violation of rights or human rights, right? Human rights violation, that someone's rights were violated. That's what they charge those officers with, right? Civil violation.
Civil rights violation.
Civil rights violation. You're right.
So that's civil rights violation, which is still criminal. Because if you killing somebody, you're teasing them. That's you're taking.
Course.
So it's still criminal.
Of course. Okay, so but we're talking of a federal charge of a civil rights violation versus the state charge of second-degree homicide, manslaughter. So when the feds pick it up, will they go after the civil rights violation?
That's the thing with the feds, they may have, especially with a lot of the evidence that I've read that come out, if they obtained that search warrant with by lying, saying that the Postmaster General gave them information that the packages were, that's going to be a criminal charge.
And you just brought in something different. If they can support evidence that they committed perjury or falsified documents to get it, that was not in good faith. All this is true, but at this point, they have nothing to support these speculations.
But that's the thing.
But that, to me, that part of it that's another issue. That's a sub issue. The main issue for me is your reckless behavior by just firing aimlessly at, again, you're supposed to be shooting at this person and he not touched, but you kill an innocent bystander. That's a criminal charge.
But the Fed, when they do it in the federal system, they load you up.
Yeah, they give you everything.
They give you everything. They find you told some bubble gum when you was 12, they'll put that on you. You know,
and,
they load
and
you
listen,
up.
They don't put charges on you that ain't gonna stick either.
Exactly. So it makes
everything gonna stick.
They're very meticulous. So and they document everything. But
Smokey, you was about to read something?
Yeah. So I know it's a lot of civilians that's probably watching us also, and there's some law enforcement also that's not well versed, or it's been a minute since we've went over these things. But murder. I'm going to the definitions. Murder, the crime of murder is the killing of one human being by another. Whether that's intentional, and that's accidental, it's usually not murder except in case of felony murder. Unlawful, as opposed to the lawful killing. That's what you're talking about, Sam. The lawful killing is unlawful, as opposed to lawful killing by a police officer of a suspect during a shootout, for example, and done with malice of forethought. Malice of forethought was sometimes erroneously called premeditation. It states the state of mind of a person. It says they have the intent to kill, intent to inflict very serious bodily injury, extremely reckless indifference to the value of human life, or intent to commit a dangerous felony.
Now, read that one more time, because everything that I have said, you just summarized in that statute. So could you read it one more time for me, please? Right.
The crime of murder is the killing of one human being by another. That is three different things: intentional, unlawful, and done with malice or forethought. And malice or forethought is sometimes erroneously called premeditation.
So this one falls in the category number 2, unlawful.
But that's murder. That's murder. I mean, it's levels to this. It's
murder, but I would say negligent homicide. That's how I would classify this.
He's giving you 3 levels, and it doesn't fit into either one of them. When you look at the elements step by step, you say, was this a element?
But that's murder.
That's just murder. That's not the levels.
That's murder. That's not homicide.
These are the type of murders. You have first-degree murder, which is a deliberate, premeditated killing, generally considered a first-degree murder.
Okay. Do they have enough to sustain that charge?
No.
Okay. Now let's
go to second-degree murder. And while reporting shooting of Trayvon Martin, George Zimmerman was charged with second-degree murder. The reason he was charged with second-degree murder is that Zimmerman shot Martin, and there's no evidence that the killing was premeditated. To win a conviction, the prosecutor would have to prove to the jury that Zimmerman intended to inflict grievous bodily injury on Martin.
Did those officers have premeditated intentions?
Nope.
Okay. All right. Let's move on.
No, they didn't do second degree.
Okay. So let's move on.
Okay. Felony murder. Let me see. They're giving an example here. Let's assume by example.
That's basically somebody dying while you committing a felony.
Before the example, can you just read the statute as it reads before the example?
I just told you what it is. Felony murder is you committing a felony and somebody die in the process.
Smoke reading statute. Let him read the statute.
Oh no, I'm not going through the statute. I'm doing a Reader Digest version. The statutes are long and they got too many legal words.
Look like somebody ain't being transparent. All of a sudden, you want to slow down on your.
Listen, that's what felony murder is. It's you committing a felony and somebody died. That's what felony murder is.
Matter of fact, I posted in the link. Aggravated.
But I want you to read that last part because it says something about malice intent. That's where you were reading it, and they didn't. And you can't prove malice intent.
Not felony murder. Not felony murder.
No, not second degree. No, felony murder is if you charge in the participation of a crime, a dangerous felony, and you kill someone, that's felony murder.
Thank you. I just said that. I know the law.
The next one is aggravating circumstances. Any murder committed under certain circumstances, such as lying in wait or murder targeting a person of a particular position, like a police officer, judge, firefighter, can lead to a more severe penalty, severe sentence, including death penalty. So those are aggravated circumstances. Okay, the next one is manslaughter. Manslaughter is the unlawful killing of one human being by another without malice or forethought. There are several types of manslaughter, including 1, involuntary manslaughter. This often refers to an unintentional homicide from criminal negligence or reckless conduct. It can also refer to an unintentional killing through a commission of a crime other than a felony. They give an example of a Las Vegas jury finding a man guilty of involuntary manslaughter after a single punch to a fellow casino customer who died when he hit his head as he fell. He got charged with involuntary manslaughter. Voluntary manslaughter, the next one, is when a murder charge is reduced to manslaughter due to mitigating circumstances, such as a heat of passion or diminished capacity. The reduced charge is sometimes voluntary manslaughter. The next one is vehicular manslaughter. Nobody was driving this one, but this crime charge, the driver has no intent to kill or cause serious bodily injury, but operating a vehicle with criminal negligence, called gross negligence, during commission of a misdemeanor cause somebody's death. So those are the different levels.
Involuntary manslaughter is what would apply here, but it would fall under the actions were negligent or reckless.
I agree, if they charged them with that.
Right.
That would have had to been presented.
And from the looks of the grand jury, they didn't get that information.
Well, thanks for reading that. You know, the people know the law, or the people have heard what the legal statute reads, and then they can apply it any way they want, but you can't fit a peg into a round hole or a square peg into a square hole or whatever it goes. But the legal application is what it is. You know, now we can force it, but if you just take it for what it is, I just don't see where they can prove criminal intent.
You don't have to prove criminal intent. All you have to prove is that your actions were negligent and your negligent actions led to a death. That's all you got to prove.
In the words of one of my favorite characters, Lonzo from Training Day, it ain't what you know, it's what you can prove.
Right.
Bingo.
And they can prove that their actions were negligent and their negligent actions caused a death. They can prove that. Actually, the feds already have, because they said they actually narrowed down who gun fired the shot.
All right.
So
needless to say, I will be staying tuned to this this saga as it continues. I think all of us will. But
absolutely.
one thing, a lot of the drama I think would be minimized if it was just full transparency. Full transparency. If you didn't present it, say, hey, we didn't present that. We can't talk about the circumstances why we didn't present it, but we didn't present that. You're giving the people, you're not giving them details, but you're giving them an answer. When you don't know, that's the worst thing.
The fact that there is no transparency is indicator enough.
But that's the thing. A lot of people are making assumptions that may not. I mean, that's when people get into their feelings. Instead of being logical, they become emotional, because that's what's going to come into play. So you want to take that. You want to present it logically. Like, hey, you can understand you didn't present that for reasons you may not be able to tell. Just tell them, hey, stand by. It's going to be some more. Just stay tuned. If you didn't present it, we didn't present it. If we did, they said no, they weren't going to prosecute. Tell them that. Tell them something, though.
Just like in the Michael Brown case, when the grand jury there decided not to indict, they didn't leave it blank.
Exactly.
Grand jurors don't do that.
Yeah, I mean, it could have been other things, but whatever they got, that's what they got. That's what happened. Let the chips fall where they may.
Right. All right, Sam. We at the end. Do your thing.
This was a very good discussion, because I don't think nobody wants everybody agreeing, because a lot of times you can only get to that common ground when you have differences of opinion, and you can talk about them respectively and start to merge into that same lane of that course that you're trying to go. So I think, this right here, our viewing audience should be able to appreciate that we do have sometimes differences of opinion, but the goal is still the same. And that is to say the uncomfortable truths, or whatever our individual truths may be, but we're going to say them. We're going to talk about them. We're going to try to bring the perspective in of what the law says, because I'm really harping on the legal application. We're also talking about the law enforcement perspective on how law enforcement do things at that moment in real time. We talk about, how people feel, that don't have this insight, knowledge, or the foundation that we may have. And by no means are we legal scholars, but I think that we do give people something a little bit broader than what they may be reading on social media or some of the news outlet, because we ain't got a horse in the race or a dog in the fight, as they would say. We all retired, and we just say what we say. So with that being said, we're going to ultimately get justice. And whatever the case may be, if you believe in justice, sometimes you have to accept those legal verdicts, even if it doesn't coincide with what you ultimately wanted on a personal level. If you believe in justice, sometimes you have to accept those verdicts, And if you don't, and if you still have a grievance, that's when you go to your politicians, and that's when you go to your legislation and you ask for the laws to be changed. But if the laws are on the books as they are, and they are applied properly, you can't argue with the verdict if that's what justice is. So we keep saying we want justice. Justice start with the legal basis first. And that's what I'm trying to drive home, because if we keep acting on emotions, you're going to continue to have the civil unrest, and people are not going to be accepting of what happened. And a lot of that comes from the mistrust that the public have in our leaders. And we're back to that. They don't trust our leaders, that they're doing the right thing, that they're applying the law, that they're holding their people accountable. So that's where the mistrust comes in. And that's why we need reform. And that's why we need to vote more courageous and ethical leaders into office, into these positions of authority. So that's my skill.
Like you said, Sam, you definitely, hit the nail on the head. You cannot just sit back and say, hey, they'll take care of it. Let somebody else vote. It's going, whatever happens, happens. My vote don't count. If you don't have a vote, you ain't got nothing to say. If you don't vote, don't complain. Don't complain whatsoever. Because you just going, how many people sacrifice, and women and minorities have sacrificed so that you can go there and make your choice. That's a choice. I mean, how much freedom? Other countries, they don't have that choice. They can't go in there and say, this is who I vote for. Don't get disenfranchised because people say, hey, well, neither one of them is who I want, or they ain't got who I want on there. Okay, you got to get, it's like if you sit down there. I know back in the day, we sat at the table, we knew I wanted to eat what was on the table, but we had to eat it. If you didn't eat it, you was going to get hungry. You ain't have a choice. So now you got a choice. When you grow up, you got a choice of what you want to eat. So now you got a choice. Pick what you want, who you want. If it's not what if not your flavor this time, hey, run for office yourself. Get somebody who do, represent your thoughts and your desires. Then encourage them to run. It's a free country. And first thing you got to do is, one of the things that we do, or what we talk about, is survive the encounter. You don't survive the police encounter, you ain't going nowhere.
I will end with earlier this year, Russia had an election, and Vladimir Putin won the election overwhelmingly. So I say that to say, how many people actually believe that was a fair election? I'm gonna just go out on a limb and say, yeah, everybody knew the outcome of that election before the election date. So I really would hate for this particular country to end up in a situation where we're looking at the outcome of an election before the election even happens, because we know the person that's in charge wants to be in charge, stay in charge, so they're gonna make sure they do that. And I think we're heading down that pathway. So we have to vote in numbers so overwhelming that particular person can't rig stuff. And also, hold on, let me say this. Deep down in my heart, I believe this. I hope I'm wrong, but I do believe with these electronic vote machines, some votes gonna get changed. I believe that. I hope I'm wrong though. But go ahead.
Here in Duval County, right here in Jacksonville, they are currently allowing the mail-in votes to people who want to do mail-in votes to start right now. They actually started a couple of days ago, and they're getting an overwhelming response. So instead of requesting and waiting on a mail-in ballot, you can actually go to the supervisor of elections office, actually get a mail-in ballot in hand at that moment, fill it out, and give it back to them. And so it's really another version of early voting, but yeah, they started that here in Duval. So I'm saying that to tell for all the Duval County residents, if you want to avoid the lines and you want to ensure that someone official receive your ballot, you have that option. Go to the supervisor of election, request the mail-in ballot, fill it out, hand it back to the clerk, and yours has been officially been received.
Good information. Hey, look, all the things that we talk about, the information that we have, the things that we know, some of it is, lived experience, some of it is work experience. A lot of it you can also look up yourself. Just trust your sources outside of Wikipedia. That's not a reliable source.
Yep.
Do your own research. Listen to us, take what we say, and then go look it up.
I would go one step further. Listen for yourself. They have a presidential debate tomorrow night. Watch it. That way you hear yourself. You don't have to have somebody in the spin room or somebody on Fox News, CNN, MSNBC, or somebody else giving you their opinion of what was said. Listen to what you hear yourself and watch the body language for yourself. I mean, I cannot express enough. Do your own research. Go to resources that are, like the indictment. Look at that. I mean, I listened to the indictment from the judge reading it herself. I didn't go through some, one of the media sources or something like that. And please do not get your information off Facebook. I had to kind of check somebody earlier. They made a post. It was trying to find the flames of racial divide because they brought up. I think this post started out with a 13-month-old child. Antonio West was murdered. He didn't get justice. His killer was a black male, and he needs to be done. So after about 11 comments on this guy's page, I couldn't help myself. I had to chime in. I told him, first of all, you need to get your facts straight. The child was a 13-month-old child named Antonio Santiago, not Antonio West. And he did get justice because his killer got life in prison. And the reason I know that is because I worked that case from the time he got shot. And I testified in the trial. So that, after that, they had no more comments on that page. That's one of the reasons I'm saying, don't just repost stuff, research it. Make sure if you don't know, don't repost it. Make sure you know what you're talking about. Because if it's something that egregious, that's fanning the flames or something like that, and it come across me, I'm gonna have time. I'm gonna make time for you. I'm gonna make time. I'm gonna tell you. I'm gonna make time for you that day.
That's it.
All right. Well, thanks for tuning in.
Appreciate y'all.
Peace.
Peace.